Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy podcast. Today, we are finishing our three-part series on DWI sentencing in North Carolina. We started on sentencing factors in episode 31. We talked about the DWI sentencing levels in episode 32. And today, we are going to be talking about preparing your client for sentencing and then how to advocate for your client during the actual sentencing hearing. All right, so in terms of some of the other items that come as a result of the courtroom consequences of the charge, other miscellaneous sentencing items, you obviously have the cost and the fees that can be associated with a DWI. So in terms of the lab fee, if you have a client that has a blood draw, anytime that there is a conviction, the lab has been returned, the state will generally ask for the $600 lab fee. Make sure that you ask for that lab fee to be waived, regardless of kind of what the circumstances are under which the lab were drawn. You can ask for that lab fee to be waived, but in some in particular, it's pretty likely that they would be waived. So if the officer goes straight to blood, so does a lab by consent, never asks for a breath test. The lab is not done because of a refusal of breath testing that led to a warrant to get blood, but the officer just chooses to go straight to blood. Make sure that you ask that fee be waived, because that is something that the judge is allowed to waive. And in that context and that situation, it makes sense for there to be a waiver of the lab fees, because it is the officer that is deciding blood versus breath. And if the officer for no reason, and I've had this happen a lot recently, if the officer for no reason is choosing a blood draw, then it's not really fair for the defendant to have to pay that. So if the blood is by consent, for sure, make sure that you are asking for that lab fee to be waived. In terms of the community service fee, if you have a client that lives out of state, the $250 community service fee generally should be waived. And so ask for that $250 fee to be waived if your client is requesting to be allowed to do the community service out of state, and then you return those hours to the court. Just make sure that you're communicating that to the judge. If you have a client that has done, again, a sufficient, we've talked about this really at level 3, 4, and 5, but if you had a client that has done a sufficient amount of inpatient treatment, you can ask for the client to be given an active sentence with credit for inpatient done. So let's just assume that you've got a client that has done 30 days of inpatient treatment. They thought that they had a real alcohol issue. They wanted to address that. They've done inpatient treatment. Ask the judge to, instead of giving the normal level 5, 24 hours community service, 60 days, suspended sentence, place them on unsupervised probation for a period of 12 months, kind of the normal circumstances, ask the judge to give an active sentence with credit for time served. And the reason why is that you can basically save all of the monies that would typically be related to the DWI. You can pretty much save all of those if you ask for an active sentence. You basically eliminate almost every cost that would be associated with the case. So ask for an active sentence with credit for time served. In terms of probation, just be aware of the duration of probation. You can ask for a shorter period of probation. So there's really not any statutory requirement that probation be for a certain period of time. I have had clients that are in the military that I have requested a 6-month period of probation on a level 5 versus the kind of normal 12 to 18-month period of probation. I have had professionals in all kinds of different work. One that I can remember in particular was a massage therapist that had to have a new basically a renewal of their professional license 8 months down the road. And they were not allowed to be on probation, whether supervised or unsupervised, at the time that they were filling out their application for the renewal of their license. And so we explained all that to the judge, and the judge allowed that person to have basically a 6-month probationary sentence versus a typical 12 to 18-month period of probation. So if there's going to be issues with your client professionally in terms of licenses or being able to leave the country, whatever it may be, make sure that you have a conversation with your client. And then if you can legitimately explain that to the judge, most judges are going to be, relatively workable on that front, because unsupervised probation is effectively meaningless probation anyways. So why jeopardize somebody's professional license or livelihood when you don't need to do that? If you're given the information as a judge to kind of go outside of the normal sentencing consequences, outside of the normal period of unsupervised probation, most judges are going to do that. In terms of requesting, supervised versus unsupervised probation, in terms of requesting unsupervised, again, the more work that you've done before sentencing, the higher chance maybe that you have for unsupervised. In Buncombe County, it is pretty typical that if you're a level 2, 1, or A1, you're going to be on supervised. Generally, if you're a level 3, 4, 5, you're going to be on unsupervised probation as long as you can pay all your monies. You otherwise have kind of done everything you needed to do in terms of having an assessment. Generally, if you're 3, 4, 5 unsupervised probation, generally level 2 or more serious, then you're looking at supervised probation. But again, there are exceptions to the rule. So I had a client a couple years ago that was from out of the country. He needed to get back to South America kind of as soon as possible. He did not want to violate any type of probation by leaving the country. So I talked to the DA's office and said, look, I've got a client that's a level 2. I know normally this person would be placed on supervised probation. He wants to leave the country. He can't be here. He needs to go home and support his family. Would you approach the judge and agree to consent to there being an unsupervised probationary sentence? And the probation officer or the judge was just fine with that. The DA consented to it. So again, if you ask for something and you give a legitimate reason for your request, most of the time the state and the judge are going to be supportive of that. Think about requesting a transfer to unsupervised probation. If your client has been placed at a level 2 or a level 1 on supervised probation for 24 or 36 months, some judges will basically say, after 6 months, if your client's done everything they need to do, they can request to be transferred to unsupervised probation. Other judges remain silent as to that. But, 6 to 12 months down the road, it's pretty likely, because I've just done this in enough different jurisdictions that I've kind of seen a lot of judges get on board with this. It's pretty likely that if your client has been successful on probation for 6 to 12 months, that the probation department will not oppose a move to unsupervised probation. They can't really consent to it or even recommend that, because the probation department's guidelines don't really let them request a transfer to unsupervised probation or support a transfer. There's some specific language that basically keeps them from kind of going in and advocating for a transfer to unsupervised probation, but most of the time they will not oppose a move to unsupervised probation. So at the point that you kind of recognize in your jurisdiction that, hey, we could request a transfer to unsupervised probation 6 months into an 18-month supervised probationary sentence on a level 2, go ahead and ask for that, because you're saving your client, at that point, close to $1,000 in supervision fees, all kinds of time and hassle of being on supervised probation. So be aggressive with that. Do that. I mean, it's a relatively easy request. Most judges will get on board with it, especially if there's a good reason for doing it. And then in terms of the conditions of probation, if there are reasons to kind of ask for special conditions of probation. So for instance, if your client has to travel outside of the state regularly for work, if there is a need to be able to get to kind of multiple counties or whatever it might be, travel issues, make sure that whatever conditions of probation may need to be modified, you try to do that in the courtroom and talk to the judge about that so that that can be built into the judgment. Otherwise, you're going to have to come back and spend time requesting the judge to amend the original sentence as well. So in terms of objective number 3, we're talking about the kind of the communication of the expected sentencing outcome to the client. And in terms of preparing your client for a DWI sentence, the courtroom consequences, that begins in the consultation. You want to communicate this to the client at the earliest possible opportunity. You want to communicate this to the client at the earliest possible opportunity, and that is during the consultation. If you are not getting the client prepared for sentencing during the consultation, you need to start doing that. That should be your number one takeaway from this learning exercise. That should be your number one takeaway, is that I need to start preparing my client for sentencing during the consultation, because that gives your client the most opportunity to get done the things that you need to get them done. It doesn't help the client to learn that continuous alcohol monitoring is going to possibly replace jail time the day that they are scheduled to be sentenced. They need time to get that installed. If they're going to do inpatient treatment for 4 months prior to sentencing, they need time to get that scheduled. And so the faster that you can get your client prepared for sentencing in terms of, hey, here is the realistic picture of what would happen if you are convicted, the more time that you're giving them to prepare for that. So in terms of the consultation, the goals of the consultation are, first of all, to ease the client's anxiety by providing clarity and answers. And in respect to sentencing, this is a huge part of what is happening during the consultation, because when the client calls you, they don't know if they're going to jail over the charge. They don't know what is going to happen in the courtroom. They don't know if they're going to have to do classes. They don't know if they're going to be on probation, what the requirements of probation are. As soon as you start to provide the information to the client, there is going to be a sigh of relief, even for bad information, because now they know what they are facing. When they come into you, it's like a black darkness of what possibly could happen into the courtroom. You are basically painting the picture for them onto that canvas of, hey, here's what the sentencing hearing, the sentencing outcome is going to look like. And again, it may not be a pretty picture, but at least it's a picture. At least they know exactly what they are looking at, as opposed to this kind of like, man behind the curtain unknown of what they are facing. In order to provide helpful sentencing information, you need to ask the right questions. And so in terms of consultation goals overall, your entire consultation, you have to ask the right questions in order to identify what attack points that there are on the case, what motions you might have to file. But in terms of, again, looking at the sentencing aspect of the case at the earliest moment that you get involved, which is at the consultation, you need to ask the right questions to identify what grossly aggravating factors there are out there. aggravating factors, what sentence level the person is likely to fall at, what obstacles there might be on the client's end in terms of different strategies to preparing for sentencing. So you need to identify the right sentencing information so that you can then give the appropriate advice and paint the right picture for the client about sentencing. Another consultation goal is to explain the consequences. So you want to, during the consultation, explain what the client is going to expect. And again, this kind of goes back to point number one in terms of easing the anxiety, but very thoroughly explaining what the client is facing in terms of the courtroom consequences, driving consequences, impact on life, impact on job, impact on insurance. All of these consequences need to be clearly laid out during the consultation, and not in some sort of just like vague, broad, generalistic terms, but as specific as you can get to the client's particular criminal history, circumstances, circumstances that led to the charge, what they're looking at in the courtroom. You got to get as specific as possible at the earliest possible outcome. Another goal of the consultation is to give the client a game plan. This is something that we call an action plan. So again, when applying this part of the consultation goal to basically sentencing, you should be providing the client, when they walk out of your office, a written plan on what they need to do to get prepared for sentencing. The whole reason why we started giving action plans out at the office is because I would go to court with clients that would repeatedly tell me, hey, we need to get a continuance because I don't have an assessment. You never told me to get an assessment. And this would happen with the same client, court date after court date after court date, with them saying every single time, hey, you never told me that I need to get an assessment. Like, that's why we got a continuance the last time, was so that you could get an assessment. So the action plan actually stemmed from that particular problem of telling the client immediately in writing at the first moment of interaction, you need to get an assessment. That's like priority number one. But we also now spell out a whole laundry list of other things that the client needs to do in order to prepare for court. You need to start attending AA. You need to go to inpatient treatment, or at least explore inpatient opportunities. You need to explore the possibility of getting a continuous alcohol monitor installed. You need to contact your insurance and ask them for a letter related to any damages that were caused to other people or vehicles, property damage, whatever it might be. You've got to spell out to the client what they are expected to do to be prepared for sentencing. Another goal of the consultation is to restore the client's dignity. And in regards to sentencing, you need to make sure that you are very clear with your client that this is not the end of the world, that this is not the end all be all of life, that there's going to be worse things that happen in life. You need to spend a significant amount of time after you've talked about the serious ramifications that are going to come from the charge if there's a conviction, to also telling the client, you can move forward with this thing and be successful. You can have a major impact on your family and on your community, no matter what happens in relation to this particular charge. So you got to spend some time restoring your client's dignity. So once you have actually collected information from the client during the consultation, that is then when you're going to start transitioning into explaining the consequences to the client. And my transition to explaining these consequences to the client is basically standardized. It's the same transition every single time. I will basically say, okay, let's spend a couple of minutes talking about the consequences of DWI North Carolina. I'm going to give you a whole lot of information, and I will follow up with you by sending you everything that we're going to talk about by email. so that you can pay attention to what we're talking about, as opposed to feeling like you have to write everything down. So that kind of takes the pressure off in terms of feeling like they've got to remember each and every single thing that you say. Then I basically will say, in North Carolina, a DWI is a misdemeanor traffic charge. It's not a felony offense. It's a misdemeanor charge, and it's one of the few misdemeanor charges that has its own sentencing structure. So in North Carolina, there are 6 sentence levels for misdemeanor DWI sentencing purposes. There's a level A1, which is the most serious sentence level, and then there are levels 1 through 5, with level 5 being the most mitigated punishment level. So as counterintuitive as it sounds, level 5 is the best sentence level to fall at. Level 1, A1, is the worst sentence to fall at. So once you've kind of laid out that kind of introductory overview of the consequences, what you're then going to do is kind of, based on the information, the extensive information that you've collected during the consultation, you're then going to lay out for the first time what the client is going to be expecting based on the anticipated sentencing level outcome. So the first and most important thing is to identify the likely sentence level. Are we looking at a level 1 or are we looking at a level 4? So again, ask the questions to reveal the grossly aggravating factors, and obviously the plethora of mitigating factors that you expect you would be able to argue. Most importantly, you want to understand the grossly aggravating factors and the aggravating factors. Explain to the client the maximum jail time. If it's unlikely that the person is looking at any maximum jail time, still explain to the client the maximum jail time. I always explain the maximum jail time, even on a level 4, on a level 5. I will say the maximum jail time, it looks like based on what we've talked about, you're looking at level 5 sentencing. The maximum jail time at a level 5 sentence is 60 days in jail. It's unlikely that you're going to spend any time in jail. In fact, it's almost out of kind of realistic possibility that you would spend any time in jail based on what you've told me and based on how I know our judges would sentence at a level 5, but you still want to give the maximum jail time and explain that maximum jail time. You also want to explain the likelihood of jail time. So if there is an expected jail sentence, you need to explain that so that as of the beginning date of contact with you, the client can start to mentally prepare for spending time in jail if that's going to be a likely outcome. So you need to have that conversation. If there is a realistic possibility of an active sentence, you need to explain that. If there is zero possibility of a jail sentence, talk through that as well. Not zero, but very small possibility of jail time. Talk through what the anticipated outcome is. You don't need to sugarcoat anything. People need to be able to plan. So don't sugarcoat anything. Don't make things out to be worse than they are. You also don't need to use fear tactics. Level with people. Give people the correct information, the anticipated, expected outcome that you would see in court so that they can start to make the appropriate plans. If you have a more serious sentence, if you have an A1, a 1, or a 2, then you need to explain the minimum jail requirements and how a judge could use inpatient treatment or continuous alcohol monitoring to potentially replace the minimum sentence or to shorten the true minimum sentence, as we've talked about. You need to explain the alcohol assessment and treatment. Every single DWI client that comes in the door, you should be explaining the alcohol assessment and treatment process and telling them to get that done. There is no person charged with DWI, or at least it is a very rare situation for somebody charged with the DWI that when they walk into the office, you can say, well, that charge is going to be dismissed. That very, very rarely happens, if ever. So you need to tell the client, we are going to prepare for worst case scenario. And because an alcohol assessment is both required if you're convicted and also a brownie point, a mitigating factor, let's go ahead and get that done because we know it would be required if there's a conviction. So make sure that you explain that. And then obviously you're going to follow up in writing with the client to let them know what they're going to be expected to do. An alcohol assessment and treatment are going to be on there. So now you've told them in the consultation and you followed up with them by email to let them know that this is going to be required. Explain the difference between supervised and unsupervised probation. What is the difference? So in terms of my explanation of unsupervised probation, I'll tell the client, unsupervised probation is basically probation in name only. You're not reporting to a probation officer. You're not paying any fees or fines to be on probation. There's no drug screens. Nobody's coming out to your home. It's effectively the technical means by which a judge avoids giving an active jail sentence. That's what it is. So explain that. Explain the difference between supervised and unsupervised and which one the client could anticipate facing. Again, don't sugarcoat it. Just level with people about whether or not they're going to be on supervised or unsupervised probation. In terms of preparing for the actual sentencing hearing. So I guess just to step back for 1 second. After you've given all of this information to the client during the consultation, you have now given them the maximum time available to prepare for worst case scenario. If you've told the client that is looking at a level 1 sentence, you need to do inpatient for 30 days in order to avoid this minimum 30-day jail sentence. You need to do continuous alcohol monitoring for 120 days. And you're going to be expecting to do at least 10 days in jail or 10 days of inpatient treatment. You have now provided the client the maximum amount of time to get those very extensive and expensive projects, getting a continuous alcohol monitoring device installed, going into inpatient treatment. You've given them the maximum time to now make plans for that. When you basically save the sentencing anticipated consequences for a later moment, you lose that opportunity to give your client the maximum possible time to prepare. So take advantage of the consultation, tell the client what to do, how to kind of move forward. They're going to appreciate that. And I guarantee that you will separate yourselves from a lot of the competition by doing that for the client. You will separate yourself from the competition by doing that, because if you're giving the client this information, it is setting you up as the expert. It is setting you up as the person that has your client's back, that has their best interest at heart, that has the knowledge on how to deal with this situation, whether it's a level A1 or whether it's a level 5. So now we are going to turn to part 4 of our training. This is the final part of our training for today. We're going to turn to preparing for a DWI sentencing hearing. And so we've talked about grossly aggravating factors, mitigating factors. We've talked about the sentencing factors. We talked about the sentencing levels. We've talked about how to explain sentencing consequences to the client during the consultation. So at early stage of representation, now we're going to concentrate on the actual sentencing hearing itself. It is important to know what to expect in a judge's sentencing philosophy, in the sentencing outcome. What I have learned through practice, doing this many hundreds of times, is that you do not want This is the same theory in terms of never ask a question on direct or cross-examination that you don't know the answer to, right? Don't ask a question that you don't know the answer to. Do not enter a guilty plea, if at all possible, unless you know the sentence that the judge is going to give. How do you know what the sentence is going to give? Well, first of all, you've got to watch other attorneys in the courtroom with similar cases in front of a judge. You've got to use your knowledge that you gain of doing repeated cases in front of different judges and how each judge is going to sentence. But the easiest way to do to make sure that you know exactly what sentence is going to be given is to ask. Ask. This is going to sound simple, but it's amazing how many times I have personally, both on myself, and this is shame on me, and then also seen other attorneys enter a guilty plea in front of a judge and they don't know what the judge is going to do with that. If you don't know, don't be surprised. Go ask. Ask to approach the judge with the DA, explain what kind of case that you have, how the sentencing factors are probably going to play in, and then see if the judge will indicate to you what the expected outcome would be. You know, I've gone up many times on a level 2. Your Honor, I'm about to enter a plea for margin number 93. Mr. Smith, he's charged with the DWI. He's very likely looking at level 2 sentencing based on the record that the state has provided me. He's done 53 days of CAM. He would be asking to be allowed to do CAM instead of the jail time. I was wondering if Your Honor would consider allowing him to do that, and if Your Honor would give him credit for the time that he's already done on the CAM towards the total 90 days. Give them that information and see if the judge will indicate to you, okay, yeah, that sounds good. You'd be surprised how many judges are absolutely fine with knowing that, but basically giving the indication of, okay, yeah, I'll buy into that. That sounds like a reasonable outcome. And a lot of judges appreciate this because now instead of having to make a decision, on the fly in the courtroom where it appears to some extent that there's an adversarial proceeding, the state on one side and the defense on the other. Now, by doing this at the bench, you give the judge the opportunity to ask questions and not look silly about kind of, how does CAM work? What am I allowed to do at a level 2? Judges, you would, again, imagine know backwards and forwards everything that we've talked about today during our kind of sentencing training. That's just not the case. Judges are learning just like we are all the time. And so you provide them by going up ahead of time with the opportunity to ask a question and not look silly. You have you give them the opportunity to think about it and then say, well, actually, you know what? I'm not comfortable with that, instead of forcing that on them when there's no way to kind of back out of the sentencing hearing. So go up and approach. And recently, the kind of best example of why this is important is that I had a client in the courtroom that was looking at a level 2 sentence, was a single dad, had a job, had been wearing continuous alcohol monitoring for, I think, around 45 days as of the date of the scheduled hearing. Had a very friendly DA that was working that day in the courtroom. I said, hey, do you mind if we approach and ask the judge about this? Because the judge that was on that day, was scheduled to be on that day, was out because her husband was sick. I would have expected that she would have been fully on board with doing the 90 days of CAM in lieu of minimum sentencing. And we had a visiting judge out of the Greensboro area that was scheduled on the bench that day. So I asked, hey, do you mind if we approach and talk to the judge? And I am sure glad that I asked that, because we approached, I explained the circumstances to the judge. My client's been on CAM. Would you be willing to, give him credit for the CAM? And the judge very, very clearly indicated under no uncertain terms that he did not appreciate my request to kind of see what would be expected, that he didn't want to get locked into a corner. He indicated, hey, I see all kinds of things come out of left field that I'm not told about during these bench conferences. Under no circumstances should you expect on a second DWI offense that I am just going to be locked into minimum sentencing. So I'm not going to commit to anything right now. And that was all I needed to basically walk away from there, turn to the DA. Based on that conversation, I'm going to have to ask for a continuance because I can't, in good conscience, enter a plea where I think that there's a good chance that my client is now looking at some sort of lengthy jail sentence and has no plans to take care of his kids. So the DA was fine with continuing the case, but had I not approached and just blindly assumed that the judge was going to buy in to that continuous alcohol monitor, I don't think that judge, based on, when he had retired, I don't think that judge had very much familiarity with the continuous alcohol monitoring device and how it worked. So again, without asking if I had entered that plea, I think that there's a real high chance that things would have gone sideways in that sentencing hearing. So the best thing you can do for your client is, if you don't know what the judge is going to do in terms of a specific sentence on a specific client's case, the best thing you can do is ask the DA to approach with you and figure out what the judge is going to do, or get the answer I got, which is, I'm not going to be locked into anything, and see if you can get a continuance so that you can put it on in front of a court that might give that level of desired predictability. So always ask what the court is thinking about that specific issue. In terms of second point with regards to sentencing hearing, know your audience. Who is it that you're speaking to? Well, obviously in a sentencing hearing, you are speaking to the court. You are speaking to the judge. So it's important to make sure that you are appropriately addressing the court. As we've talked about, make sure that you are giving specific statutory citations to each mitigating factor that you are arguing applies. Make sure that you are presenting all of the relevant evidence. So understand that you're talking to the judge, but your primary audience in a sentencing hearing is not the judge. It's not the judge. The judge is, for the most part, this is for most judges, is looking for grossly aggravating factors, mitigating factors, is going to balance those the way that they're supposed to be balanced, and then is going to give a sentence that is relatively predictable based on other sentences that judge has given in similar past circumstances. So they're just looking for the formula. How many grossly aggravating factors? How many mitigating factors? How many aggravating factors? What sentence level is this person? Boom, here's my, basically formulaic spiel of sentencing. Here's my court order. Here's my order in regards to sentencing. So again, as much as you want to give the judge the ammunition that they need to make sure that they're finding your client at the lowest appropriate sentence level, your primary audience is your client. Your primary audience in a sentencing hearing is your client. And when you start to recognize this, you will become a real advocate for your client in the courtroom. You are going to present things differently when you recognize that your primary audience is your client. This sentencing hearing is the culmination many times of a multi-month waiting period between charge and conviction date. And your client is expecting you to go to absolute war on their behalf to show the court that they are a good human being. That's what a sentencing hearing is really about at the end of the day. What kind of human being your client is. And your client wants you to do everything possible to present them in the best light in front of the judge. So what this means is that giving the minimum sentencing factors of mitigation to get to a level 5 is not enough. What you're trying to do in the sentencing hearing is build up your client's worth as a individual, as a family person, as a member of the community. That's what you're trying to do. So that is your primary audience, your client. You're speaking to the judge, but your primary audience is your client. Base what you're doing in sentencing around that. Go to bat for your client. Build up your client's good works, the things that they are contributing to in their community. This is that moment. This is the time. This is their day in court. So recognize that that is your primary audience. You're also speaking to the DA. You're also telling to the DA by doing a really stand-up job in a sentencing hearing, I really know my stuff about DWI law. So you're speaking to the DA. You're explaining to the court what the DA maybe didn't provide in terms of grossly aggravating factors or aggravating factors. You're also speaking to other people in the courtroom. You're showing other attorneys in the courtroom, I take my job serious, so that you can hopefully earn some referral business from the courtroom. Hey, this guy's really going to war for his client. There are attorneys that in the counties I practice in go to absolute war for their client. And it is such a beautiful thing to watch. Somebody that just goes to war for their client and really lifts up that client as a person that has taken seriously the offense, that has worked hard to kind of learn from that bad choice, and that has done a lot of good in their communities. It's a real beautiful thing to watch. So make sure that you are communicating to the audience of other attorneys, to the people that are watching from the gallery. All of these different people are part of your audience. It's not just the judge. It's not even primarily the judge that you're talking to in terms of your audience. So in terms of the specifics that you want to go over with the court during a sentencing hearing, you want to discuss the circumstances of the charge, including any explanation of your client's life that led to the poor choice to drive. My client had just lost his mom. My client had just had a bad breakup with his fiance. My client had been using medications because of a past accident that he had been involved in, and then was no longer able to get those prescriptions, turned to alcohol. Whatever the circumstances are that led to being in a bad space, if that's the case in your particular sentencing hearing, make sure that you're talking about that. Give the backstory to why this charge occurred at this specific date and time in your client's life. Make sure that you argue every mitigating factor by specific statutory subsection, including subsection 7, which is the catch-all subsection of mitigating factors. Maybe you're arguing 5 mitigating factors under subsection 7, but make sure that you're arguing by specific statutory subsection every mitigating factor that applies. Communicate to the judge the sentence level that you believe is appropriate. Don't just give the mitigating factors. So don't just assume that because you've stated 3 mitigating factors and the DA has stated 2 mitigating factors, that the judge is automatically going to find a level 5 sentence is appropriate. Make sure you communicate to the judge, I believe that level 5 sentencing is appropriate because X, because of these 4 mitigating factors that I presented, Judge, or because of the mitigating factors outweighing the aggravating factors. Make sure you state to the court the specific sentence level that you believe is appropriate. And whether that happens at a bench conference ahead of the actual sentencing hearing or during the sentencing hearing, again, make sure that the judge isn't mulling over in their mind, is this a level 1 or a level 2? Make sure that you say this is a level 2 sentence because there is a prior DWI within 7 years. There was a license revocation, Judge, but it was not due to impaired driving for the purposes of the statute. Therefore, level 2 sentence is appropriate. Here's what we're asking for. And then transitioning into what sentence level, from what sentence level is the appropriate sentence level, then make sure that if there is a specific sentence that you are requesting, that you request that specific sentence. So even on a level 5, I always indicate to the judge, Your Honor, my client would be respectfully requesting to be allowed to perform 24 hours of community service here in Buncombe County. Your Honor, my client, we believe is a level 2 for sentencing purposes. He would specifically be requesting or respectfully be requesting to be allowed to do continuous alcohol monitoring in lieu of the mandatory minimum at a level 2. He has completed 45 days of continuous alcohol monitoring. Up to this point, we'd ask that you give credit for that. We'd ask for XYZ reasons that he be placed on unsupervised probation. So if you're requesting a minimum sentence, if you're requesting that can be used, if you're requesting that inpatient be used in lieu of jail time, if you're requesting community service, if you're requesting that your client be allowed to be on unsupervised probation, make sure that you specifically say that to the judge. It never hurts to ask. It never hurts to ask for a specific kind of relief if the judge doesn't think that's appropriate. And again, likely you found out about that at a bench conference, but if the judge doesn't think that's appropriate, they'll tell you. But you'd be surprised what a court might grant if you ask for it versus if you make no request. So make sure that you specifically request the sentencing outcome that your client desires. So hopefully this training on sentencing has been helpful. Again, this is one of the main areas that we can work on as criminal defense attorneys because of the fact that there are such a high volume of DWI cases that ultimately end up in front of a judge for sentencing. If we are not really working on our preparation in terms of both preparing the client and ourselves for the actual sentencing hearing, if we're not working on being prepared for sentencing, we're doing our client a major disservice. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community. And be sure to leave us a rating on iTunes. See you next time.